Santa Clarita and Canyon Country. You are on the Legal Line with Dennis Kennelly, and a bit later we're going to get to our superstar guest, Dolores Leal, who is one of the best plaintiffs, sexual harassment and gender discrimination lawyers in Southern California, and has been recognized as such by a number of institutions. As always, we like to comment on what's going legally speaking. We've been following the healthcare debate and what's going to happen to Obamacare from the perspective of the current situation. It was announced last night that the nation's largest insurer, Aetna, has totally pulled out from the remaining two markets that it services. So the number of insurance companies willing to participate in Obamacare are diminishing, which tells me that they've got to do something with it. Problem is, as anybody who is got coverage knows, the parties passing the new legislation are going to have a huge problem with the people that will lose coverage under it. And there is absolutely no way that I've been able to figure out, and that anybody has written about, where everybody that's currently covered is going to be covered under the new plan. And there's going to be a heck of a difference between what happened in the House bill, and what happens in the Senate bill, and they're going to go to conference. And I think that's going to take most of the time up until the summer recess, and I think it's also going to continue into the fall. So this thing is going to be really, really interesting to watch. I don't know the finances well enough to know how much money the plan as it exists now has. I assume that the government will fund it. So it's going to be an interesting situation to watch. And speaking of interesting situations, the big legal news has been the firing of Mr. Comey, the former FBI director by President Trump. On the way in, I was listening to the deputy press secretary explain that while there was a memo by the Deputy Attorney General of the United States expressing his desire and his loss of confidence in Mr. Comey, that Mr. Trump had already made up his mind, and no matter what the memo said, he was going to fire him. The big issue seems to be the timing of it, and that is that the FBI is actively investigating the supposed Russian interference in the 2016 election in which Mr. Trump was elected, and the role, if any, of Trump people, namely those with his campaign and who later wound up in his administration, like Michael Flynn, in that interference, whether there was collusion or whatever. So that's going to be a really, really interesting story that I don't think the press is going to let go of. And it puts the Republicans in a really, really tough bind, because I think the Democrats are looking for enough evidence to try and impeach Mr. Trump. I think there are a number of Republicans who would go along with him for the good of the party, in their view, especially with the problems that the Republicans are going to have with what happens with health care. So this is a prediction, not a suggestion, but my prediction would be that the Democrats and the Republicans who will go along with them will move sooner rather than later, so that they can put as much distance between Trump and the 2018 elections, because the way it looks now and the way the polls are going, the Republicans are very likely to lose their control of both the House and the Senate with what's going on now if Trump continues in office, and if the gaffes that seem to be happening on a daily basis continue. So it's going to be a fun summer. Even though Congress will be out of session, I think there'll be a lot going on. So that's personal opinion. It's a prediction. I've been I've been pretty good so far on predicting what's going to happen. I think keep your eyes open this summer. But let's move on to the topic of the day, and that is sexual harassment. And as I said, we have with us Dolores Leal, who is a partner. What's the name of the law firm, Dolores?
It's Allred, Morocco, and Goldberg. We're in Los Angeles.
Okay, and if the name Allred strikes a chord with you, that is Gloria Allred, whose name appears in the paper at least weekly doing something.
It's the same Allred. Yes, it's Gloria Allred. I've been here since 1991, so I've become part of the family.
And tell us about the firm and what kind of cases you take.
Well, the firm is a civil rights firm, but the majority of the cases we take are employment-related cases. I just handle nothing but employment-related law cases representing employees. We don't represent any employers. And, the employment cases can range from sexual harassment, which is the topic today, to other forms of discrimination or wrongful termination, whistleblowers, that type of a case.
Okay. Now, and the firm has been around now. The firm has a Los Angeles office, and you recently opened in New York, correct?
We did. We opened a New York office a couple of years ago. A couple of our attorneys, including Gloria. Gloria is licensed to practice in New York. It's Gloria Allred, and there's an associate. Actually, she's now a partner, Chrissy Chung, who is also licensed to practice in New York. And so we're all over the place. If we take a case in the middle of the country, then all we do is co-counsel with someone who is licensed in that particular state.
Yeah, that's what I've done in the past. I've made what are called pro hoc vice appearances in about 10 states, and it's always a lot of fun to see how other states or federal districts work, and it kind of makes life interesting. Okay, let's get to the basics, even before we do that, if anybody wants to contact you or your firm, how do they do it?
Well, they can contact us through our phone number, 323-653-6530, or through our website, which is www.amglaw.com. In other words, allredmoroccogoldberg.com.
Great.
Or allredmoroccogoldberglaw.com. I misspoke, sorry.
You don't go to your website too often, but I'm sure any number of people do. Okay, let's get to the basics on sexual harassment. How many different types of sexual harassment are there, basically?
Oh, my goodness. Well, there are two general types. We call them two various legal theories. One is what we call quid pro quo, which is a Latin phrase, and the translation is this for that. In other words, have sex with me, and I'll give you a promotion, I'll give you a raise, you can keep your job. So those are the quid pro quo cases. The other type is what we call the hostile work environment claim. Those are the more common claims, and that is where either a coworker or a supervisor engages in sexually inappropriate behavior at the workplace. So those are the two types of cases in sex harassment. Sex harassment, just kind of to backtrack, is prohibited both by federal law and by state law. So the federal law is called Title VII of the Civil Rights Act, and that federal law is overseen and administered by a federal agency called the U.S. Equal Employment Opportunity Commission, so the EEOC. The state law is called FEHA, the Fair Employment and Housing Act. And FEHA is overseen and administered by a state agency, which is called the California Department of Fair Employment and Housing. So those are the two agencies that oversee these two laws. Both of these laws prohibit sexual harassment in the workplace.
Now, you used to work for the EEOC, didn't you?
I did. I started there in, 1976. I was a baby. And I had a number of positions. The last position I held before I left was that of a senior trial attorney. So I left in 1991 to join the firm, the Allred firm. So I've been doing employment law all of my adult life.
As have I, except for my stint as a prosecutor in the military, which I really enjoyed. But, okay. Now, generally speaking, how does it work with these agencies? Do they take every case that's brought to them?
Well, not every case. I mean, what happens is these agencies, they're more modern now, so now you can go online and make an online appointment. You go in, you present your information to them. If they believe that you have sufficient information with which to assert a claim, and it's what they call a prima facie case. So if they think you have enough facts to warrant a complaint, they will take a complaint. Depending upon the agency, the timelines vary, but both agencies will serve a copy of the complaint on the employer. So the employer will know that a complaint was filed against them, and the agency will then ask the employer to provide the agency with a position statement. In other words, a response to the charge of discrimination or charge of harassment that was filed. And after that happens, sometimes these agencies invite both sides to participate in mediation. In other words, a process whereby both parties will try to see if they can resolve the dispute through the EEOC or through the DFEH, and with a goal of trying to reach a settlement. If there's a settlement, then that's great. It's done and over with. If there is no settlement, then the agency will do an investigation. They will assign it to an investigator, and the investigator will do the investigation, and after they finish the investigation, they will issue a decision. And the decision will be either, yes, we found evidence to support the allegations of harassment or discrimination, or no, we didn't. And these agencies attempt, if they find that, yes, there is evidence to support the allegations, these agencies then attempt to, I'll just say, remedy the wrong, if you will. If they did not find evidence to support the allegations, then they close out the case, and they will issue what's called a right to sue notice to the complaining party.
Now, if you get a right to sue notice, but the agency has closed out the case and found no discrimination in their view occurred, is that finding admissible in court should you choose to pursue it civilly?
Courts vary. The federal courts are different from the state courts. There are some decisions that I'm aware of in federal court where they say that it's a trial de novo. In other words, we're not going to take into consideration, or the jury is not going to take into consideration, the agency's decision. So we're starting all over again, in essence. The state courts, there is no definitive response, so it's going to be up to the trial judge to decide whether or not the decision comes into evidence. So typically, however, if someone calls me and says, oh, the EEOC or the DFEH, had my case for the last year, they did an investigation, and I got a no-cause determination, and I got my right to sue. Will you help me? Chances are that I probably will not be able to help them because, what is the employer going to say to the jury? Look, ladies and gentlemen of the jury, the agency responsible for investigating these complaints, they weren't able to find any evidence of discrimination. Why should you? So, if the judge allows that to come in, that's very obviously very, very harmful to the employee. So, another thing that the person can do, however, is file a complaint with the EEOC or the DFEH and immediately request a right to sue. They don't have to necessarily go through the whole administrative process. They can ask for the right to sue if they have an attorney who's willing to represent them. And a right to sue notice is necessary. It's absolutely necessary. That's the only way we can file a lawsuit. It's a permission. It's a permission slip, if you will.
It's kind of an administrative hurdle. But it's now a lot easier to execute than it used to be. I mean, now you can go online and get the right to sue, both federally and with the EEOC. Isn't that correct?
Federally, we can't get it online through the EEOC. No, they have to actually issue it. The state does have a program online where you can go in, enter all of the information, file your charge, and immediately request your right to sue. And that right to sue is good for 1 year from the date of issuance.
Yeah, and that's important. I would remind our listeners, you are very important to this show. So if you have a question for either Dolores or myself on sexual harassment, any aspect of employment law or entertainment law, our number is 661-298-5487. You're a very important part of the show, and we're always interested in that in which you're interested. So feel free to give us a call. The EEOC and the DFEH, did they actually follow through on every case on which they find merit? Namely, do they try every case that they get, or do they occasionally say, hey, you've got money, Mr. Plaintiff or Ms. Plaintiff, and we have limited resources, we can only try so many cases?
They do. They have to pick and choose. They don't litigate each and every case. When I was at the EEOC, we didn't litigate each and every case where we found cause, we found reason to believe that there was evidence of discrimination or harassment, and we attempted to conciliate with the employer, and the employer, in essence, said, take a hike. We're not interested in settling with you. The EEOC did not litigate each and every case. We just couldn't. I mean, we didn't have enough resources, and the DFEH is the same. I mean, they're government agencies, so they have to pick and choose.
And do they tend to take cases that are relatively precedent-setting, if they can?
If they can, absolutely. Yes, yes. I remember when I was there, they represented, or we represented when I was there, was a we. We took cases against the farm workers, on behalf of farm workers, against agricultural employers. And those were cases where the farm workers had a very, very hard time finding lawyers in those rural areas willing to represent them. So the EEOC had a class. Back then they weren't called class actions. They were group cases, but in essence it was a class action representing all women, for example, who were not allowed to work a particular job because they were women, and that was written. It was in their policy. So that was an easy case in the sense that we had direct evidence of discriminatory intent.
Absolutely.
Yeah.
Well,
yeah.
we're going to be back after a break in about 30 seconds with Dolores Leal of the Allred law firm in Los Angeles and New York. I'd remind you, if you're interested, call in here, 661-298-5487, or after the show, if you want to talk to me, my number is 310-746-9106, or my website is easy to remember. It's Dennis Kennelly, KENNELY.com. And Gloria, again, after the break, will give us her website. And we'll be back after these messages.